SJC-12922, JoEllen, Guilfoil, v. Mary Lou Sutters, Secretary of the Executive Office of Health and Human Services.
Thank you. Good morning, Council.
Good morning.
We'll hear from Ms. Neely first.
Thank you, Your Honors. May it please the Court. My name is Lisa Neely, and I represent the appellant, JoEllen Guilfoil, in this matter. This case is about Dorothy Frank, who is now deceased, being improperly denied eligibility for Mass Health long-term care benefits because she owned a life estate in real property titled in a nominee trust. The decision of the hearing officer with the Mass Health Board of Hearings, which was affirmed by the Superior Court, is wrong because it failed to apply the correct law with respect to the nature of real property interests owned by beneficiaries of nominee trusts. So too has Mass Health simply dismissed the relevance of nominee trust law to this case in its papers. However, the nature of the ownership interest of beneficiaries of a nominee trust is the dispositive issue to be decided by this court.
Right, Counsel, go ahead, Justice Lowy.
Ms. Neely, so I think Mass Health looks at this as a revocable trust. I understand your position as a nominee trust.
Correct.
The issue is, are there any circumstances under the trust in which the Medicaid beneficiary could be able to access the principal? And the issue here is perhaps confusing because there's 5 co-beneficiaries, and your client has a life estate. But any of the beneficiaries can revoke the trust. Then, if they revoke the trust, they get whatever they had under the trust. For your client, that's a life estate. But you've got the 5 children who have a remainder interest, right? So what if it was just one child? What if it was just one child, and all that one child who now has that remainder interest has to do is say, okay, now I have this interest in this property, and I'm just going to give it right back to mom. It's not 5 of them, it's 1. Under that scenario, is Mass Health right that this really is a revocable trust where the Medicaid beneficiary could actually access the trust property?
No, Your Honor, that analysis is not correct. And throughout its papers and throughout the course of these proceedings, both when the case was at the administrative level and when it was at the Superior Court, is Mass Health flip-flopped between calling this trust an irrevocable trust and revocable trust. And in reality, it is a nominee trust. And that distinction is extremely critical because nominee trust beneficiaries, unlike beneficiaries, say, in a typical revocable or irrevocable trust, own vested real property interests, which is almost as if they just own it outright in a deed. And that is essentially what they own. Nominee trusts are mere title holding entities. So, analyzing this case under the federal statute's any circumstances test is the wrong way to go about it.
Okay, so let's say it's a nominee trust, and let's say that all that's going on is the trustee is the principal for the beneficiary, but there's 2 beneficiaries, not 5 or 6. All right. So what does your client own? A life estate, which is not available to Mass Health. At least that's your position. So then they get the life estate. Again, why couldn't, if the other beneficiary is the 40-year-old son, why can't they just give back the property in the trust to the Medicaid beneficiary?
Your Honor, the Mass Health rules consider transfers of assets beyond a 5-year look-back period non-countable. So once Mrs. Frank deeded that property interest to the remainder beneficiaries, it was out of her name for Mass Health purposes after 5 years. They were the owners immediately from a real property perspective, and from Mass Health perspective, there would be no impact on Mrs. Frank's eligibility. If you look at the Hain case, and just to back up for a minute, Mass Health does not consider assets gifted outside of the 5-year look back countable on the hypothetical scenario that somebody that now owns those gifted assets may decide to gift them back to Mrs. Frank, for example. And if you look back at the Hain case, which was argued in 2016 in the Massachusetts Appeals Court, in a decision authored by Judge Green, he addressed this scenario with respect to Mass Health's argument at the time that assets distributed from a trust, which again, in this case, it's different, it's a nominee trust, but assets gifted from an irrevocable trust to individual children, Mass Health essentially made the same argument it's making here, that those kids could one day say, okay, well, now I'm going to decide to give it back to mom. And what Judge Green determined in the Hain decision was there'd be no legal obligation for them to do that. There's nothing forcing them to do it. So therefore, Mass Health can't treat this scenario countable under that hypothetical scenario because they're the owners. They don't have to give it back. After 5 years, it's gone from a Mass Health perspective, and what the beneficiaries or the children decide to do with it is really up to them.
Justice Flake has a question. Yes.
Thank you. Is there any question that this is a nominee trust?
No, Your Honor, not from my perspective. That was never disputed. Mass Health in its papers essentially, acknowledges a nominee trust. It just says that matter is irrelevant to the outcome of this case.
Okay, so there's no question. You're saying it's not a matter of dispute as to whether or not this is a nominee trust.
From my perspective, no. I believe what happened.
Well, I mean, not just from not from your perspective. I mean, I don't know from the perspective of the case. I mean, are you telling me that the other side is contesting this or not?
In their papers, they haven't necessarily contested that it's a nominee trust. I went through in my papers all the reasons why it is a nominee trust, how it meets all of those classic nominee trust examples. And what Mass Health does is just essentially say in its papers, well, whether or not it's a nominee trust is irrelevant to the analysis here. And we're only going to look at and apply the Mass Health rules and regulations. And that is what I'm saying is incorrect, is that if Mass Health skipped a step here, and what they should have done is looked at what is a nominee trust, a unique.
Because it's not a true trust, you're saying. It's not a true trust at all.
It's not.
The trustees don't have the obligations of a trustee of a trust, a true trust, because they're not really trustees, they're really agents, aren't they?
Correct, Your Honor.
That's been settled. That's been settled law for a long time about the nature of nominee trusts, hasn't it?
Centuries, essentially. If you look at the amicus brief, they trace cases back to, I believe, the 1800s, where this is just settled law in Massachusetts. And as recently as, I believe, last year, the Massachusetts Appeals Court addressed the nominee trust and determined that the beneficiaries hold interest in real property and it's a principal agency relationship. And this is just settled.
Yeah. Okay, so if this is a nominee trust, then there's no, then it's not equivalent to a revocable trust. The words revocable trust have no meaning in this context. Is that true?
That is correct, Your Honor.
Yeah. Okay.
Justice Butt had a question.
Yeah, no, that was along the lines of my question. I just wanted to make sure I understood. So nominee trusts are not either revocable or irrevocable. That just is not. That doesn't apply.
That is correct, Your Honor. They are not true trusts. And this is, settled law in Massachusetts. It's a principal agency relationship. The beneficiaries control the disposition. They are the true owners of the property and they own real property interests. It's as if they own it in a deed. And it's a nominee trust is a pure title holding entity. They're established sometimes for privacy reasons, record title at the registry, and the beneficiaries listed on the schedule are real owners.
So this is a way that anybody could get out of, having to use their own assets for being taken care of. They could just have Mass Health take care of them as long as they put their property in a nominee trust.
No, Your Honor, that's not really accurate because nominee trusts aren't they're very different than, say the trust that was analyzed by this court in the Daly matter several years ago, because that was an irrevocable trust where a trustee there was issues about whether there's discretion to distribute principal. Here, that is not at play at all because it's a nominee trust. So the trustee has no power.
Right, so that the person would take all of their real property, put it into a nominee trust, and then it can't be reached by Mass Health.
It's essentially as if they made a transfer via a deed. So you have to look beyond
5 years. 5-year rule, right?
Yes, correct. It's a 5-year rule. So once you make that transfer, you're ineligible for Medicaid benefits for a period of 5 years. And that is in the Medicaid statute. And, it's been called, I believe, in the Hain decision, it was called a compromise that, Mass Health allows, based on the federal statute, allows transfers, but, you're going to be disqualified from benefits for a period of 5 years. And that is what occurred here. And, the schedule reflects that the children became the remainder beneficiary owners, joint tenants with rights of survivorship in 2001. So by that calculation, in 2006, there should have been no issue with Medicaid eligibility because the transfer penalty was met.
So why isn't it true then that anybody can take any real property that they own, put it into a nominee trust, wait 5 years, and then that can't be reached by Mass Health?
It's an accurate statement to say that anybody who owns property can decide to transfer that property to another person, wait the 5 years, and apply for benefits. It is a risk in doing that because you are transferring property. I guess it's not dissimilar from other areas of the law, like estate tax planning, where individuals gift away assets as well. And it really is a compromise between what Congress has decided is an acceptable look-back period of 5 years.
Isn't this even more complicated though? Because it's not a complete transfer. She retains a life estate. And I'm nervous about the life estate because Hain doesn't decide it. Daly doesn't decide the life estate issue. And I can't tell whether it's back in this case or not, because it's not just like she gave away her property. She's retained full benefit of the property for her lifetime.
But she's retained a life estate interest, and arguably that would be the only portion that could presumably be countable under the Mass Health rules. But Mass Health has a very definitive set of rules on how they count life estates. And
I'm gonna ask Mr. Furgang that, because it seems like they're backing away from I don't quite understand why a life estate isn't significant. I know we keep ducking the issue in our cases. Hain, has the U.S. Supreme Court said a life estate doesn't matter? Because in Daly and in Hain, this issue is ducked. And it seems like it's fairly significant that you not only get to transfer your house to your beneficiaries, but you get to keep the house too during your lifetime. I just don't know what has actually been transferred here.
Well, the remainder value has been transferred, and I believe that it is settled law. In Daly, essentially the agency raised the argument that the retention of a life estate made the entire corpus.
I read the footnote in Daly. We don't decide it. We rely on a concession, sort of, and then Hain doesn't decide it either. It also relies on a concession, but I can't tell whether that concession's been withdrawn or not.
You did not decide the specific issue of how a life estate impacts eligibility. And for that, you have to look at their regulations and how they value a life estate. And in the footnote of my papers, I propose a hypothetical calculation based on Mrs. Frank's life expectancy at the time in accordance with the tables, and the remainder value of the property, which is clearly no longer hers, is that the life estate had a value of about $10,000. So if the property was sold, that $10,000 would have to be paid, say, to the nursing home. It would make her ineligible if she kept it. Potentially the agency also has a lien against it, which was discussed. So that the retention of a life estate, however, doesn't make the whole underlying value of whatever was transferred countable. It does not draw it back in.
Counsel, do you agree that the Uniform Trust Code, the Mass Uniform Trust Code does not apply here?
I agree, and I cited because it is a nominee trust, the MUTC essentially defines or carves out a specific, it talks about how a nominee trust is a mere title holding entity. So I didn't focus on the Mass Uniform Trust Code in my papers, just because my position is that this is a nominee trust and it is not a revocable or an irrevocable trust.
And if you do look at when you do look at that code, though, it defines the revocable trust as one that's revocable by the settlor without the consent of the trustee. So could we look to the Uniform Trust Code to just define what revocable and irrevocable trusts are without relationship to the nominee trust?
Yes, you could look at the Uniform Trust Code to the extent it defines revocable and irrevocable. And I think what it says with respect to revocable is without the consent of the trustee or an adverse
or an adverse interest. That's right, an adverse interest. Right. Okay.
Those definitions are controlling.
Can you address the actual language that the Commonwealth's relying on, which is decisions made and actions taken hereunder, including without limitation amendment of this trust, shall be made or taken as the case may be by any of the beneficiaries. So why does that not make this a revocable trust, that particular language?
Again, because it is a nominee trust. It is not a revocable trust. It is a principal agency relationship. And with respect to that provision, there's also another article, Article 6, which discusses how any amendments to the declaration need to be made by all beneficiaries. And that, from my position, is the operational article here. And arguably, this only speaks to the ability to amend the quote-unquote nominee trust. You know, again, the interests are vested property interests. They own interests in real property that are vested, that no single beneficiary can take away from another beneficiary.
Can they value, can I ask a question? Can they value the remainder interest that she had and impose a monetary value on that? But she retained a life interest in the property, right?
She retained a life estate interest.
Does that have a market value?
I don't know if it would have a fair market value, but under the Social Security tables, and how Mass Health looks at a value of a life estate interest, I valued it as about $10,000, just based on my calculations and how Mass Health values. And
so could they in fact get that?
She does have a life estate interest, and that is potentially the only asset that could be countable, not the whole thing. If property, say, was sold during she's now deceased, but if it had been sold during her lifetime and she was on Mass Health, that would go back to her, and it would be countable until she spent it down, for example, on her nursing home care. And all of these rules are spelled out in the Mass Health regulations.
Any further questions? Thank you, Ms. Neely. Mr. Fergay?
Morning, Your Honors. May it please the court. The issue in this case is whether the Frank family trust's assets are countable for purposes of Medicaid eligibility.
What makes you think it's a trust? What makes you think it's a trust?
Well, Your Honor, first of all, the definition under the federal statute determines whether it is considered to be a trust for accountability.
You're saying it doesn't make any difference what our rules are in Massachusetts about nominee trusts?
Your Honor, everything is determined by the language of the document itself, and this is not a trust issue per se under Massachusetts law. This is a Medicaid eligibility issue. Well,
that's your definition of what the issue is. I'm saying to you that I think it matters what the vehicle is in terms of what kind of an interest she has under Massachusetts law. Under Massachusetts law, a nominee trust is not a true trust. Isn't that true?
No, Your Honor.
It's not true. It's not true? That is not true?
No, it is not true, Your Honor. A nominee trust is a trust-like vehicle, which
It is not. It is not. It is not what our law says. It is never what our law has said about nominee trusts. Nominee trusts are not true trusts. That has been clear for years.
Well, Your Honor, I refer again to the cases where it is treated in some, where this court has stated that in some circumstances it is treated as a trust, and in some circumstances it is not. And in this case, we have to look to the federal statute to determine how it should be treated.
But counsel, the case law on the federal side says that we look at the federal judges or courts, like the bankruptcy court or whoever, are going to look at Massachusetts law to see what a nominee trust is. What's the definition of it? What does it mean? So we go back to our law again, even if you apply the statute, even if you apply the federal statutes.
Well, I don't see federal law saying that with respect to this particular issue under Medicaid eligibility. Under the federal law, it says that a trust is any legal instrument or device that is similar to a trust. It need not be a trust in the form that is traditionally accepted, as long as it has the character.
What makes this similar to a trust, counsel? What would make this similar to a trust?
The fact that the trustee well, first of all, under any examination of a property document, you look to the terms of the document, and the terms of the document in this case say, on the one hand, it is a nominee trust. Mm-hmm. On the other hand, it says the property is held by a trustee for the benefit of the beneficiaries. It says that the document, that the trust document itself may be amended.
Well, now there's two parts in that trust document you were referring to. One requires the amendment of all the beneficiaries, but another part you were pointing to, I think it was section 3, just talked about amendments. Can you explain to me what that language means to you in section 3?
Well, in a way, first of all, I would say that it doesn't matter which of these two provisions.
Well, I read them very differently. One seemed very explicit. Section 4 seemed very explicit, or whether it was 4 or 5, I don't remember. But section 3, the language was a bit different.
Yeah,
so I think it does matter.
Section 3 described the powers of the beneficiaries and basically said that several specific actions may be conducted by any beneficiary, and one of those actions included amendment of the trust. Section 6 dealt with amendment per se, and there it talked about amendment of the deed of trust, which has to be conducted only with the written consent of all the beneficiaries. Mm-hmm. And what we are arguing is, again, looking at the document and the language of the document, it doesn't matter which of those two could apply in any particular circumstance. The end result is that, unlike in a standard nominee trust, where the property is considered deeded in effect to the beneficiaries, here the document itself anticipates situations where the beneficial ownership will change within the context of the trust itself.
Well, but isn't the point that at the moment it was executed and legally, the beneficiaries had a vested interest? They had a vested interest at that point, the other 5 beneficiaries, right?
For certain instances, it is true.
Well, it's either vested or it isn't.
They are treated as having a vested interest. But from the point of view of the Medicaid statute, it doesn't care about whether or not it has a vested interest or not, because it explicitly says in the statute that the provisions apply regardless of the purpose of the trust, which in this case is to give some kind of a vested interest to the beneficiaries, and regardless of whether the trustee can exercise any discretion. And the key element normally of a nominee trust is that, unlike in the normal trust that we deal with, the trustee is empowered with the right with a certain degree of discretion. Here, a main characteristic of a nominee trust is that the trustee has no discretion. And
well, tell me what discretion this plaintiff or this person has here.
The discretion is
discretion.
It does not. There's no question that the trustee does not have any discretion. I concede that, Your Honor. But again, the Medicaid statute applies even if the trustee has no discretion. That is explicit, and in fact, that is a significant change in the provisions from the pre-1993 version. You know, in the earlier cases that were construing Medicaid coverage, they dealt with the pre-1993 version, and the key element of those decisions was whether or not a trustee was able to exercise its discretion or his own discretion to transmit funds to the beneficiary. And if he could, then it was countable.
If I could jump in for a moment and ask, so any of the beneficiaries under this trust can revoke the trust, including the appellant. But if the trust is terminated, they can terminate the trust, any one of the beneficiaries. If the trust is terminated, then all that the appellant has is a life estate. And it's just as Kafka said, well, that's another case, perhaps, or even this case, what we value the life estate to be. But all she has under the trust is a life estate. For her to have anything beyond that life estate, there has to be another transaction beyond the trust, which is that the beneficiaries gift the remainder back to her. But within the four corners of the trust, all she owns is a life estate. So all you have access to, if at all, with your regulations, is the life estate.
I respectfully disagree, Your Honor. Under the language of, for two reasons. Firstly, under the language of the termination provision itself, any individual beneficiary may terminate the trust.
What I just said.
There are two possible consequences. One consequence is, as you said, that the property is distributed to each of the beneficiaries as they're set out, as their share is set out in the schedule. The other potential alternative consequence is that the beneficiaries may otherwise direct the distribution of the property. So in the termination of the trust, the beneficiaries can direct that the property be distributed to the grantor. That is completely allowable under the terms of the termination provision. Secondly, even apart from the termination provision, as I've adverted to.
But wouldn't that be a gift? Doesn't that then fall into this category that the beneficiaries are doing this out of the goodness of their heart, not out of any obligation? So it's like the gift that we've said is not the same. That's where I get confused. Because you're saying I get your argument that they can terminate the trust and convert it into a life estate and remainderment, but I don't understand how the beneficiaries give her back the whole house unless they do it out of the goodness of their heart, because they have no legal obligation to do that. So isn't it becoming a gift?
No, Your Honor, because even under the earlier cases, like the LeBeau case, for example, there are many instances where a beneficiary can give up their entitlement to the trust proceeds for the benefit of the grantor without having any obligation.
How is that not a gift? I don't understand how that's not a gift. You don't have to give it over. Why is that not a gift?
Because it's done, well, in LeBeau, this court held that it was not a gift. That if the beneficiary can, in fact, give back part of their beneficiary entitlement to the grantor, it's countable. As long as it is done within the confines of the trust, it is not considered a gift, because as long as it is within the confines of the trust, both under the federal statute and under the LeBeau case, for example, it is still trust property, and therefore it is countable.
But that's only really a trust.
LeBeau,
go ahead.
excuse me, please.
No, go ahead, Justice Foley, go ahead.
But in LeBeau, the trustee had the discretion to provide assets to the beneficiary, and the corpus, the entire corpus, could go to the beneficiary at the discretion of the trustee. That is completely different than this situation. So I'm really confused how LeBeau helps you.
Well, LeBeau helps for two reasons, Your Honor. First of all, in LeBeau, the court said that the right to amend, first of all, was vested in a beneficiary, and it wasn't specified whether that right to amend was granted as a trustee or a beneficiary, and it was immaterial to the court's decision. All that mattered was that the beneficiary had the right to amend the trust so that the trustee could then give the property over to the beneficiary. And as I said, at that point, the fact that the trustee could do that mattered, because the pre-1993 statute required that there be some discretion vested in the trustee to transfer property. But post-1993, the federal statute eliminated that requirement for accountability. Now, the trustee can have zero discretion, as is in a nominee trust, and yet still the assets must be counted if there is any circumstance in which the property can be given back to the grantor. And those.
I guess if I could distill my problem, because I mean, maybe you're right. I mean, other taxpayers don't want to pay for people who can afford it to, you know, to have this care, be in nursing homes. That's not fair for other taxpayers to pay if they have the money to afford it. So I understand. But here's my problem. My problem is it takes a transaction beyond the trust to get what that property, real property, not life estate, into the hands of the Medicaid recipient. And that's in a nutshell, my problem is it takes another transaction beyond the trust.
Your Honor, I don't believe that is the case here. Under the any circumstances test, one of the circumstances that it could occur within the confines of the trust is that the trust could be amended by the beneficiaries, and in that amendment, they change the schedule of beneficiaries so that the sole beneficiary is the grantor. Therefore, within the confines of the trust, the grantor assumes complete ownership of the property. And in fact, the trust document itself anticipates that kind of an action. Under section 3, paragraph 3, the trust anticipates a situation where both the legal and equitable title of the property merges when it is held by a single individual. So the trust both allows for an amendment of its own provisions and anticipates that that amendment will lead to a single individual beneficiary having complete title to the property. That is a case that Medicaid insists means that the trust should be counted, because there is a circumstance where the entire corpus of the trust could be returned to the grantor, and that takes place within the confines and the provisions of the trust itself. There is no.
It doesn't depend on what could be means. Doesn't depend on what could be means. I mean, it's, in that analysis, could be is completely dependent on the goodwill and the beneficial interests of the other children saying, "Oh, mom, take it back." Yeah, I mean, you know, you can't make them take. You cannot make them do that. You cannot make them do that. So it could be is only if they want to, if they, out of the goodness of their heart, want to.
Absolutely.
Very
Yes,
slender
sure.
read. Very slender read. Very slender read.
Absolutely. And of course, the courts are full of cases where assets accountable, even if there is no compulsion for any action. The any circumstance test means exactly what it says. If a beneficiary, out of the goodness of their heart, wants to help out their family and give up their
family. Excuse me. How does that help out the family? It helps out the rest of us. Doesn't help out the family.
Well, the courts also, the reason why the accountability statute exists is because of the recognition by the federal government, and this court has repeatedly acknowledged that recognition, that is created as a way for the family together to sequester assets for the benefit of either the grantor or themselves as heirs. That is what it's a shielding device, in effect, so that either the mother gets it or they get it, but Medicaid does not get it.
What about another kind of beneficiary? Could a creditor reach and get that?
I don't, Your Honor, I don't, and frankly, the Medicaid statute is unconcerned with that. As LeBeau said, the issue of access for creditors or other purposes is immaterial to the Medicaid statute. The statute looks simply at the language of the trust vehicle and sees whether under its terms there is any circumstance in which the property could revert back to the grantor. And the fact that under other circumstances the property could be considered vested is immaterial. And LeBeau specifically says that, and indeed in the Cohen case also, it noted that the trust may be interpreted in one way under probate law for Massachusetts, and in another way under the Medicaid statute, because they serve different purposes. This is not an effort to change Massachusetts trust law, Your Honor. This is not an effort to change the relationship between the beneficiaries of the property and other parties for other reasons. This is only for the purpose of determining whether an individual has access to Medicaid benefits or not. And so if you look at this document.
Mr. Fergang, can I ask a quick question? Has Mass Health changed its views on life estates? Because at one point they were conceding that a life estate doesn't count, but it seems vaguer in this case than it has in the past. Is there a change in position out there, or do we ignore this life estate issue?
I think they have not made a pronouncement on that yet, but certainly the Hain and Daly cases have opened the door for them to go back and look at that issue again, because under those decisions, it would appear that the value of a life estate would be countable. But again, that's not the issue in this case itself. It may certainly come up again. But here, the issue is more about, do we apply the language of the Medicaid statute or not? And frankly, we have no choice, because that's what the law is. And the law is that the federal government statute is agnostic at best about whether or not this is labeled as a nominee trust or any other kind of trust. All it cares about is what the language of the trust permits. And here, the language of the trust permits the property under some circumstances.
Assuming it's a trust at all. You keep saying it, assuming it's a trust. You keep assuming that this is a trust, and I'm telling you it is not a trust.
No, Your Honor. I'm assuming that it's a trust under the definition of the Medicaid statute. Under the Medicaid statute, any legal instrument or device that is similar to a trust, not even a trust. And here,
similar to a trust. What makes it similar to a trust? How is it similar to a trust? It's because it's called a trust.
Under the terms of the document, a trustee holds a property
a
for
trustee is an
the
agent in
beneficiary.
Massachusetts law. It's not a trustee. It's not a true trustee either. Under Massachusetts law, it's not a true trustee either.
Your Honor, for certain purposes, that is correct. But in this case, the plaintiffs made a decision. They could have, the grantor could have deeded her property free of any trust to her relatives and retained a life estate. And she chose not to do that. She chose instead to create a nominee trust and take the consequences of that. And there are consequences that are both positive and negative. We don't know what the reasons are for why she chose that methodology, but the fact that she chose to create a nominee trust put it into the ambit of the Medicaid statute under 1396PD. And both the Massachusetts regulation that applies to that and the federal statute itself say, even if this document is not in all ways a trust, what they did here was an effort, should be looked at to see if it was an effort to shield the assets from being reached by Medicaid. And you look at it to see, does it have the characteristics of a document that looks like a trust, even if it isn't really a trust under certain circumstances? And I defy anyone who's familiar with the law of trusts to read that document and not tell me it looks like a trust. It is called a trust. It has a trustee. The trustee holds the property, which is exactly what trustees are supposed to do. It has beneficiaries of the trust. It has the right to be amended so that the properties of the trust can change in any number of ways. So for all those reasons, it is treated as a trust only for the purpose of counting the assets for Medicaid. It may not be treated as a trust under Massachusetts law for purposes of liability, for purposes of transfer of ownership, for purposes of taxes. There are all kinds of circumstances under which it will not be treated as a trust. But for purposes of counting assets for Medicaid eligibility, it is treated as a trust. That is what the statute clearly says, and we have to go by the language of the statute, which was indeed designed and amended to encompass these kinds of instruments, where there are efforts to shield property from Medicaid while giving the benefit to the families. That's what's happening here. And Medicaid is not counting that.
Thank you, Mr. Fergang. Do we have any further questions?
No.
All right. Thank you, counsel.